Metro codes. So if I call your name, please announce your presence. Ms. Davis?
I'm present.
Ms. Carpenick?
I'm present.
Mr. Newton?
Present.
Mr. Pepper?
Present.
Mr. Lawless?
Present.
And I am present. And so we have established a quorum. And Lisa, do I need to do the motion to have the meeting electronically, or do you need to read that first?
I'll read the first paragraph and then you can solicit the motion.
Thank you.
We are convened electronically pursuant to Governor Lee's Executive Order number 71 in order to protect the health, safety, and welfare of Tennesseans in light of the COVID-19 outbreak and still conduct the essential business of the Metropolitan government. Before we move on with this meeting, the Governor's Executive Order 71 requires a motion to proceed electronically.
Okay, there's a motion to proceed electronically. Is there a second?
Second.
Is that Mr. Pepper?
Correct.
Okay, have a motion, have a second. As I call your name, please vote on the motion. Ms. Davis?
In favor.
Ms. Carpenick?
In favor.
Mr. Newton?
In favor.
Mr. Pepper?
In favor.
Mr. Lawless?
In favor.
I'll vote in favor also, so that motion passes. We are now holding our meeting electronically per the governor's order.
In order to convene this meeting pursuant to that executive order, the board members are participating remotely, and we encourage members of the public to submit comments in support or opposition to the board electronically at bza@nashville.gov. We extended the deadline to submit comments, and any comments received by 12 o'clock noon yesterday, Wednesday, January 20th, were provided to the board for consideration prior to this hearing. Additionally, members of the public can call into the meeting at 629-255-1903 to provide comments in support or opposition to any case called on today's docket. We ask that you wait until the case is introduced prior to placing your call. Good afternoon. The Metropolitan Board of Zoning Appeals is now in session for the regularly scheduled meeting of January 21st, 2021. My name is Lisa Min, and I will be presenting the cases to the board for their review in today's public hearing. We are convened electronically. For these hearings, the board reviews the correspondence submitted in support of and opposition to the cases. The board also reviews correspondence and recommendations from other government agencies in preparation for the hearings. In today's hearing, staff will present the site plans, maps, photographs, and other documents that comprise the case record. At the conclusion of the staff presentation, the appellant will present his or her case to the board. After the appellant's presentation, we will allow anyone wishing to speak in support of or opposition to the case to call into the meeting. During these electronic proceedings, the appellant has 5 minutes for their presentation. Anyone calling in to provide public input will be given 2 minutes to speak. The appellant will then have any time remaining from their initial 5 minutes, as well as an additional 5 minutes for rebuttal, for a total of 10 minutes. At the conclusion of each hearing, the board will deliberate and then vote on that case. The board is vested with the power to act on these cases under the provisions of the Metro Zoning Code, Section 1740-180. All section numbers that we refer to come from the Metro Zoning Code, which applies to the entire jurisdiction of the metropolitan government. The zoning code was adopted by the Metro Council and became effective on January 1st, 1998. I will introduce the entire zoning code and make it part of today's record. The Metro Code requires a record of these proceedings, and because BZA meetings are recorded for Metro Nashville Network, it is imperative that anyone addressing the board should identify themselves by name and address and then make their desired presentation. The Metro Code requires 4 members of our 7-member board to establish quorum. The code also requires at least 4 affirmative votes to grant an appeal. In the event that 5 or more members are present, but the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may appeal board decisions to Chancery or Circuit Court within 60 days of the entry of the BZA order. Additionally, as per the BZA rules, an aggrieved party may file a motion for rehearing by the BZA within 60 days of the original hearing date. After that time elapses, the board's decision becomes final and no further action can be taken. If your appeal is granted, you're required to obtain the permit for which you applied. A permit must be obtained within 2 years for a board approval to remain valid. It should also be noted that if false or misleading testimony is presented to the board, any board approval could be revoked at a later time by means of a show cause hearing before the BZA. Mr. Chairman, I submit that all cases have been filed in proper order. All appellants have been notified by certified mail, and all legal notice requirements have been fulfilled.
Great, thank you.
We do have preliminary announcements concerning 2 cases being withdrawn from the docket today. Case 2021-010 and case 2021-013 have both been withdrawn from today's docket. The board utilizes a consent agenda for its meetings. One board member reviews the record for each case prior to the hearing and identifies those cases which meet the criteria for the requested action by the appellant. If a reviewing board member determines that testimony in the case would not alter the material facts in any substantial way, the case is recommended to the board for approval. The following items are proposed for the consent agenda on today's docket. Case 2021-009, located at 2430A Chapman Drive, requesting a variance from side setbacks. Case 2021-012, located at 4115 Gallatin Pike, requesting a variance from sidewalk requirements. And case 2021-015, located at 2740 Whites Creek Pike, requesting a special exception to construct additions to a church.
And
if anyone opposes to any one of these cases, they can call into the meeting now by calling 629-255-1903 and state your opposition for the board's consideration. I believe we'll pause for 2 minutes to allow for anyone to call in for opposition at this time.
Right, and Lisa, just for clarification, the case 012 for the sidewalk variance was under the condition that they paid the in lieu fee, and that was based on the recommendation of the council.
Let me confirm the council members.
No, she did. I mean, that was part of our.
That was the request, and the council member, yes, did support that.
Right. I just wanted to make sure that was just part of the record in case anybody thought it was totally getting out of the sidewalks. It was for, it had the conditions that they paid into the fine.
Correct.
And while we're waiting to hear if folks call in to object to those items, I did learn yesterday, just for the board members' sake, that we do have a new member who was appointed this week, Joseph Cole, who is a local architect, and it's always wonderful to have that type of expertise on the board. And so I think he's going to be joining us at our next meeting and as a member, and we look forward to having him serve and appreciate his service on the board. So it's going to be nice to have a 7th member.
Jessica, do we have any calls?
We have not received any callers.
Okay, seeing no opposition to the consent agenda, there's a motion. Is there a second?
Seconded. A second.
All right, I think I heard Ms. Davis seconded, and is there any discussion? We'll call the question and vote and start with Mr. Lawless.
Aye.
Mr. Pepper.
In favor.
Mr. Newton.
In favor.
Ms. Carpenter.
In favor.
Ms. Davis.
In favor.
And I vote in favor also. That motion passes. The consent agenda passes. The first case.
At this point, we would like to take opportunity to allow any elected officials to call into the board also at this time. Again, the number 629-255-1903.
We have not received any calls.
Okay, we will proceed with today's docket then. The first case to be heard will be case 2021-011. This property is located at 1806 B 15th Avenue North. Here's the overview of the zoning, and the specific unit is Unit B being built on this site. Here's the overhead view. Here's the proposed site plan showing the second unit, Unit B, to be constructed. Street view of the existing house at the front of the property. And neighborhood views, both directions on the street. They're requesting to construct a single-family residence without building the sidewalks as required, and they are requesting to contribute into the sidewalk fund in lieu of constructing. The applicant may now address the board by stating their name and address and presenting their case at this point.
Okay, my name is James Feynman. The address of the property, do you want my address or the property address?
Yours, please.
Okay, 415 Church, my address is 415 Church Street, apartment 1413, Nashville, Tennessee, 37219.
Okay, and just tell us why you're here and what you're asking.
Okay, so when I submitted my application, when I was from a lot of different people, I know that really doesn't, it's kind of irrelevant. I've basically looked at the property and I looked at the front and saw that there was a large tree there and probably 100-year-old tree there, and a retaining wall that kind of wraps around the alley and continues onto the neighbor's property on the left side. And then it borders an alleyway as well. We all were kind of under the initial impression that we wouldn't have to build sidewalks here, that we would be able to contribute to the fee, which I was 100% all for, is contributing the fee. I fully understand the needs for sidewalks in these neighborhoods. And so then I made my application and then discovered that they told me to build the sidewalks. So my purpose of going to the BZA was which I submitted some pictures. It looks like your pictures pretty much clearly show the hardship of the situation, which is to your right there, right behind that phone pole. There's a 100-year-old, probably, I couldn't bear hug it all the way around, tree right there, along with a retaining wall. That retaining wall actually continues over into the neighbor's yard, as well as it wraps that alleyway. So it's just a really, really tricky situation, especially. So I only own the back house. I don't own the front house either. This is another kind of irrelevant thing, but I guess just for you guys to consider from a compassionate standpoint. That's a gentleman with his couple kids and his wife that live in there. The way this street's designed, that sidewalk, moving that retaining wall, digging up his yard, pushing it back into his house. It's going to be challenging on all fronts. I will say financially, I will say physically, I will say mentally, on all fronts. So I was hoping to contribute to the fee. Down the road, the city, I guess, at some point with the sidewalk ordinance will come through and put sidewalks everywhere in Nashville, right? Someday that's the plan, right? Anywhere where a developer didn't build. I assume at that point, that the city would be the one to remove retaining walls and come down that whole street and do that. So I'm just hoping the board can work with me in this situation. It's really tricky and challenging. I am a builder. I have taken on this risk, so I understand the risk that I've taken. But this is going to be a very difficult situation amongst taking down that tree, which I'm hoping to God I don't have to do.
Mr. Feynman, this is David Taylor, and I was curious to know, the planning department had proposed designing and building an alternative sidewalk plan, which I guess is their way of saying it doesn't have to be up to the standards exactly because of the retaining wall and the tree. Is it possible to fit a sidewalk in the space that you have, or is that also a hardship?
mean, I would say it's possible. I mean, that would eliminate, another thing is where it is. It's, I believe that I'll be forced to improve that alleyway. So, I mean, that's another factor to it. So even if we do a modified plan, I'm going to be forced to move into that alleyway as well. And I guess the reasoning for that is partially because it borders commercial property. If you look at the metro layout there, you see that the next to the right is not another house. It's an actual commercial property. I'm hoping at this point, to do the in lieu fee. That would be my, it's more expensive than it is generally for me to build a sidewalk. However, considering everything that will have to go into this particular sidewalk based on everything, it's going to be very, very tough for me.
And there are currently no sidewalks, at least from the aerial view that we see. Is that correct?
No, there's not. I think there is some, but they're way down at the end of 15th, I believe. I know when I first bought this property, there wasn't any. And I had talked to a codes rep at that time, and he said, based on the fact that there's no other sidewalks on the street, that you should be eligible for the fee. And then, of course, I applied. I believe that there are sidewalks now. It had been over a year, since the time when I was talking to him. And then, so there are sidewalks, I believe, I'm not 100% certain, towards the end of 15th, on the other side, not Buchanan, but the other side over there. There's nothing in the general vicinity. There's nothing anything within a couple doors down any direction.
Yeah.
No sidewalks anywhere.
Looks like there's a new construction behind you that on 14th that has a sidewalk, at least from the aerial view we see on our screen right now.
Right. One street over. Yep.
Okay. Is there anything else to add at this point? And before I ask the board if they have any questions for you?
No, sir. Thank you.
Okay. Board members, are there questions for the applicant? Okay. Mr. Newton.
Yeah, can you explain what you mean by that you have to improve the alleyway?
So let me look real quick at my survey. We had to, whenever we submitted, they made us submit an alternative plan that included the sidewalk, and then they had us add specific notes. So bear with me 2 seconds. I'm going to pull this up. All right. So they had us notate that I have to install an alley ramp. Let's see, alley ramp, and it's got a metro standard, like a whole detail that they want, and then they want me to take down that existing retaining wall that wraps around. So I have to create an alley ramp on both sides of that alleyway. So, and I'll have to kind of improve it. I can't just leave it rock, right now it's just like dirt, crush and run right now. So the only way I'm going to put functionally an alley ramp in there on both sides is to improve it all the way across it. And they've got a detail. I mean, you probably, if you have access to Metro's website where I pulled my permits, there's the site survey, and it shows all the details on there.
I have this. We have the sidewalk plan in our packet, but I don't see the thing.
I think it's on the actual survey, not the sidewalk plan. The sidewalk plan is typically just the 5-foot grass strip and the detail on the sidewalk.
Okay, thank you.
Any other questions for the applicant? All right, Mr. Feynman, did you have anything else to add at this point?
No, sir.
Okay, then I will close the public hearing. And there was no opposition to this case, is that correct?
We have a caller.
Okay, I have a caller. Okay.
Right now, the appellant has 3 minutes remaining, and then they'll have an additional 5 after we have the person in opposition speak,
Okay.
for a total of 8.
Is the caller on the phone?
Yes, we're about to send them through.
Perfect, thank you.
We're not sure if they got disconnected or they hung up, so they're not there anymore. Looks like they may have hung up.
Okay. Well, if they're not, if they don't call back in the next 10 seconds, then. All right, doesn't look like they're back.
No, sir.
Okay, then, and there were no other callers?
There are no other callers.
Okay. And so, Mr. Feynman, anything else to add at this point?
Oh, I was going to say, I think I'm muted. No, sir. I'm not sure how all this process works.
Well, if you have nothing to add, then I'm going to close the public hearing and the board will discuss and vote.
Okay. When do we know the results of that vote?
Well, as soon as we're through discussing, you will hear all of this over the computer or phone or however you've called in, and we'll know that as soon as we have a chance to discuss and vote. So if you have nothing else to add, then I will close the public hearing.
No, sir. Thank you.
All right, Mr. Lawless, I'm sorry, did you have a question?
I was just hoping that the applicant could articulate, besides for potentially having financial issues, what the hardship is.
And to add on, this is
Okay. Yeah, I'm gonna reopen the public hearing officially, and then Mr. Lawless had asked a question about to Mr. Feynman about hardship. So,
I mean, I guess it really depends on what we consider hardship. I mean, building a sidewalk in most scenarios is just building, you're just digging it out, figuring out your layout per your site plan and installing a sidewalk. In this case, it's removing a retaining wall, pushing the earth back, building a new retaining wall, putting the earth back, and then having to go in and put a ramp on either side of the alleyway and improve the alleyway. So when you say financial hardship, I mean, I'm not, I can afford to do that, but as far as, I think this law was intended to build sidewalks in neighborhoods. And I think it's a good law. I'm a biker. I like to ride my bicycle. I live downtown in the city. I ride my bicycle down in the city. They finally put a bike lane in on Commerce, so I can run down Commerce without feeling like I'm going to get hit by a car. But, for most of the city, it's not bikeable. I can 100% appreciate, having a place to ride a bike or walk or travel in a neighborhood, period. When this law was created, I think it was created for just that. When you get into situations where a homeowner owns a piece of property and one homeowner, hence they did change the law, or I believe they modified it so that if somebody has a sidewalk on one side of their property and then they live on a corner and it runs 150 feet down the other side of their property, when they changed this law, that person's property value changed, because now in order to build a house there, they've got to build 200 feet of sidewalk, not 50 feet. So it just creates different variables for different people with different pieces of property as to what it costs and what's involved. It's not a one size fits all scenario. So in my scenario isn't 200 feet of sidewalk, but my scenario is I've got a house of existing family that lives there, and we'll do what we have to do, but me to put a sidewalk in there, I've got to dig their entire front yard up. I've got to move a retaining wall because I just so happen to be on an alleyway. I have to improve an alleyway and put ramps in. So it's not just the sidewalk, that's the only response I really have to that.
And did it exist when you bought the property? Did the house and has it changed materially since you acquired it?
Yes, the home, actually, it's actually a friend of mine who owns the front house, and he divided it and he created an HPR. Back when I was first interested in this property, the HPR, the sidewalks laws didn't even exist.
I'm just asking a simple yes or no type of answer question. I'm not trying to get a long explanation on it, but it was that way when you bought it, correct?
Exactly the way it sits now is exactly how I bought it.
Okay, thank you.
Ms. Davis, you had a question?
Yeah, I was just wondering if the applicant had the opportunity to review planning's recommendation for this? Because it sounds like they took into account some of the hardship and sort of proposed that an alternative sidewalk be built, you know, in light of everything that's going on in this area. And so I just wanted to know if the applicant could speak a little bit more directly to what, if anything, are the issues with planning's recommendation in this case.
I never saw that. I'm not even sure what you're talking about. I never saw that. All I ever did is I went and applied for my permit. I proposed to pay the in lieu fee. They came back to me and told me that that wouldn't work. They made me modify my plans to include the sidewalk plan. There was additional comments given showing that I had to show the alley improvements and different things. They wanted specific things shown. So we added those, and then they allowed me to get my permit knowing that I was going to attempt to get a variance from the BZA. And that was that was it. I never saw anything different. Maybe that's my ignorance to not know where to look, or I've never heard it.
Yeah.
What you just said is news to me.
Yeah, Mr. Feynman, this is David Taylor again. I think that the planning recommendation, the final one for this case, just came out this week. So I'm not sure how those are communicated to the applicant. So it may not be something that you've seen. Again, I don't know exactly. I know when they come to us, I'm not sure how they come to you. But their recommendation, it specifically says the applicant shall design and build alternative sidewalks to match adjacent or existing alternative sidewalks per Public Works final guidance. And so I think that basically is when they say build an alternative sidewalk, that really is, to me, they're saying, well, propose something and work it out with Public Works, but alternative meaning not to the letter of the,
Standard design.
The standards. And we may be I think that the board is the only one that actually gets the planning recommendation, since they are recommending to the board, what they propose. So oftentimes the applicant is does find out at this hearing, but so you may not have as much time to react to it. But that is the what we have in our packet as their recommendation. Ms. Carpenter, you had a question?
Go ahead. Sorry. Go ahead.
Yeah, sure, I did. Do you know the distance between the existing electrical pole and the retaining wall?
It's about 5 or 6 feet. I don't know the exact distance, but it's roughly about 5 or 6 feet.
Okay, thank you. That helps.
I can give you my email address, or you may already have it. If you could send me that detail, if that's something that I am allowed to see.
Well, you are allowed to see it, but I just what the one sentence of the recommendation is. That's all there is. So
I would still beg of you to consider the in lieu fee. I know it's it might even be more expensive for me to pay that fee, but if I can avoid that sidewalk personally, I would like to. If it is what it is. I knew going into this call that it could go either way, and that's facts of life that I will accept. So
okay. Was there anything else that you'd like to add? Or are there any other board members who have questions? And nothing else to add at this point? All right, we're going to close the public hearing and discuss. Ms. Carpenter.
I think it's feasible that the alternative sidewalk be built. And I think I would personally vote for that, but the applicant's also willing to pay into the in lieu fund, which we've also approved in the past. I do see the hardship as the tree, not wanting to uproot the existing 100-year-old tree. Also, I was going to say, if we do, he should be dedicating the right of way if we do approve the in lieu fee option.
And this is David Taylor, and I do agree with you. I almost, I kind of like to think of kind of different scenarios, and I would certainly like to exhaust the alternative plan, but certainly be open to paying the fee. And so I was kind of thinking, and I think that I know the alley question was mentioned, and I know that's come up before in a sidewalk case that we heard, and I thought that ended up being, that was a public works issue. That public works was requiring that, not the sidewalk law. I may be wrong. I just remember us not having any kind of authority to deal with an alley curb or alley apron improvement in what we were dealing with. But I'd almost be willing to say to approve the recommendations of planning to develop an alternative sidewalk with the understanding that if a decision that's agreeable to both parties can't be reached, then the applicant could come back one more time to ask to pay into the fine. But you all may not want to add that permission, and that's fine too. Ms. Carpenter?
Well, I would second it and then open it up. Obviously, that would open it up for discussion too.
Mr. Newton, did you have a question?
I was just going to say something similar to Ms. Carpenter there.
Okay. Well, then I'll move that as a motion that that the applicant the variance is to allow the applicant to design and build an alternative sidewalk plan with the approval of Public Works, and should the applicant not be able to come to a mutually agreed to plan, the applicant may come back prior to 6 months, the 6-month wait period, to this board to request to pay, to make a request to pay the in lieu fee, which we may or may not grant as an aside, but he would have the right to do that if he can't work out an alternative design with Public Works. Ms. Carpenter?
I'll still second that.
Motion and a second. Is there any other discussion? Okay, we will vote and start with Ms. Carpenter.
In favor.
Mr. Newton.
In favor.
Mr. Pepper.
In favor.
Mr. Lawless.
Against.
Ms. Davis.
In favor.
I'll vote in favor also. That motion passes 5-1. Next case.
The next case to be considered is case 2021-014, located at 1425 4th Avenue South. And there is a special exception request, requesting exceptions from the front setback, rear setback, and sky plane restrictions within the CS zoning district to construct a mixed-use building. This is the overview of the parcel, Zone CS. Here's the aerial view of the existing property and surrounding areas. Here's the footprint of the building. The front setback per the CS zoning is 15 feet, and they're requesting a 0-foot front setback. The rear setback of 20 feet is the requirement, and they're requesting a 10-foot setback. And here's an illustration they've provided of the elevation showing the request to encroach within the sky plane. at the setbacks, the maximum height allowed is 30 feet, and they're requesting 49 feet 4 inches at that point. And as you can see by the lines they've illustrated in their example, showing here's the CS zoning requirements, and here's their request, so that you can see the portions of the building that are within encroaching into the sky plane. Here's a rendering of the building. Another illustration. The existing site. And the view from the surrounding areas. At this point, the applicant may now address the board. Please state your name and address and then present your case.
Thank you, Lisa. My name is Jay Fulmer, 2002 Richard Jones Road. As Lisa said, we're asking for a special exception to heightened setbacks, which the board has authority to approve under the special exception clause. Planning has recommended approval of the application, and we hosted a neighborhood meeting through the SNAP neighborhood organization. I actually received a letter from them that was received after the final deadline to get it in your hands. And so I'd like to read that into the record if possible. It states that on Monday, January 11th, SNAP hosted a community meeting where the architecture and development team for the proposed project presented their project. And after a thorough presentation, time for community questions and answers were presented. Many neighbors asked detailed questions and found the answers pleasing. At this time, no neighbors within the Wedgwood Houston community have openly opposed the proposed project. SNAP has been the voice of the Wedgwood Houston community and neighboring partner to the Chestnut Hill community for more than 40 years. We are an organization organized by the people for the people of our community, as we have both endured and welcomed change over the last 40 years. We have been fiercely inclusive of our neighbors. Thank you for your interest in our neighborhood's input. We also sent out a letter to the mailing list provided by the zoning department. This was supplemental to the standard notice, and it gave a brief description of the project, or that we were requesting a special exception. And it advertised that we were having this neighborhood meeting. And so that's supplemental to how SNAP advertises. And it also included a Gmail email address for people to email in any questions or how to reach us. And we have really no traffic on it whatsoever. So we really appreciate the help that Councilman Sledge has put forth today. And we're happy to answer any questions you may have.
Ms. Carpening.
Excuse me, this is Lisa Minton. At this time, we'll invite any members of the public to call in support or opposition to this case. And then you can ask your questions. We'll check with Jessica and give it a few minutes to let people call in if they'd like to.
Is it okay for the board to ask questions at this point, or do we need to wait for the callers?
We don't have any callers. We can let you know if we get some while y'all are discussing.
Okay, thank you. Ms. Carpenter?
Thanks. I was just wondering about the small neighboring building to the right side of the image we're looking at. Is that a residence or a business?
It is not a residence. I believe it is owned by the Exotic Center of Tennessee. And so I'm not exactly sure what operation they have inside. I know that the owners of our property have been in communication with them and the immediate neighbor next to it. And there's been no opposition presented.
Okay, thanks for clarifying.
Mr. Fulmer, this is David Taylor again. The one thing that I was having a little trouble figuring out on the on the drawings is just how far the face of the building is going to be from the street. I see on one drawing, it looks like there's a 12-foot sidewalk, and then there's a planter of some sort that doesn't have a dimension. And then there's a photograph that's just a rendering that shows doesn't look like to be that big, but maybe it's just all sidewalk, just concrete. And then there's a right-of-way line that says current is at 50, and then the future's at 74, which, you know, again, I'm not an architect, but it seems like that's adding 24 feet to a right-of-way, which doesn't mesh with what I saw with 12. So
I completely understand the confusion. The right-of-way, it would be the half of the delta, because the other half would be in the future be presented by the opposite side of the street. But we're required to have bigger sidewalks for the major collector and street plan. And so I believe those are 4-foot grass and 8-foot sidewalk. And the easiest way to see it is likely on page 6 of our packet. The red dashed line that we are asking for is a sky plane and setback. That is at the property line, which would be 0. We are going to have balconies that overhang, and then the front doors swing out, you know, from the front of the building. And so our building is actually set 5 feet back from the future property line. And I apologize for the confusion between the renderings and the plan. So I'm glad you asked.
So does that mean that, so the base of the building is how far? I'm looking at the,
There'll be an 8-foot public sidewalk, and then there'll be another 5-foot zone before you reach the base of the building. You know, vertically above you on the residential floors, you're going to have balconies that cantilever over, but the primary face of the building will be 5 feet back from the back of that public sidewalk.
Let's start at the street. So I've got the curb at the street. Do I have a 4-foot grass strip, then an 8-foot sidewalk, then 5 feet before the building?
Correct.
So I've got 4 feet plus 8's 12 plus 5. So the face of the building will be 17 feet from the curb.
Correct.
Okay, that's exactly what I needed to know. Are there other questions from the board at this time? Okay, are there any callers?
There are not.
Okay, does the applicant have anything else to add at this time?
Not at this time. Just happy to field any more questions that may arise.
And so you did mention Councilmember Sledge, and I don't remember seeing a letter from him, but you had indicated that he'd been working with you and supports the project.
Well, we have kept him in touch with everything we've been doing. We've sent him copies of the package.
Okay.
We have alerted him of the neighborhood meeting. You know, I don't think that he wanted to, you know, he wasn't in opposition by any means, but I don't know if he was necessarily, you know, carving out the time to document support and reach out. But he was very happy that the neighborhood was supportive.
Yeah.
And so I don't want to speak for him. Please don't, you know, think that I am speaking for him, but we have kept him fully in the loop with everything we've done today.
Okay. Any other questions? Okay, then we'll close the public hearing and discuss. Any thoughts or comments from the board? Ms. Carpenter.
Well, given that it's all under a special exception and there's not a hardship needed, I find the requests in line with the requirements of a special exception.
Okay. Mr. Newton?
I would agree, and just want to say that I appreciate the diagrams and renderings. It helps to understand things. So thanks for that.
Yeah, my only concern was the front setback and the distance from the street, which was, I think, on one of the drawings appeared, you're trying to plop a conceptual building on top of an existing picture, and it appeared closer than what it actually was going to be based on the testimony of the applicant. So I agree with the two of you. Mr. Newton.
As someone who's created similar things like that, I can tell you how difficult it is.
All right. Does anybody have a motion or any other comments? Ms. Davis.
Sorry, it took me a minute to find the mute button. I was just also going to say that I appreciate the leveling of engagement that the applicant had with the community, and that he was forthright in sort of depicting the councilman's stance on it. He was very upfront about that, and I appreciate that. Sometimes people aren't.
Right. Mr. Newton.
I'll make a motion that we approve the special exceptions as indicated in the application.
I will second it.
That Mr. Lawless?
Yes, sir.
All right. Motion by Mr. Newton, seconded by Mr. Lawless. Is there any discussion? We'll call the question and vote and start with Mr. Newton.
In favor.
Mr. Pepper.
In favor.
Mr. Lawless.
In favor.
Ms. Davis.
In favor.
Ms. Carpenter.
In favor.
I'll vote in favor also. That motion passes unanimously. Good luck to the applicant. Next case.
Next case is case 2021-016, located at 2832 Blue Brick Drive. They're requesting a variance from the maximum allowable square footage for a detached garage within an RS10 zoning district. There's an overview of the parcel. Aerial view. The site plan submitted, site plan submitted showing the proposed garage. And they are replacing an existing carport as part of the project, I believe. The applicant can confirm that. Street view of the existing house and the surrounding area. If the applicant may state their name and address and speak at this time.
My name is Jimmy Kilgore. My address is 2832 Blue Brick Drive in Nashville. When I bought this house, it had a carport. Carport's roughly 10 feet shorter than the proposed length of the garage that I'm building, or that I would like to build. Sorry about that. I also have a little building that was built at some point back there. I'm a handyman. I do lawn work. I have all of my tools. Some of my tools were in that little red building. Most of them I've kept under the carport. I have a little trailer under there that I haul stuff with. It's an eyesore. I've cleaned it up about once a year. Leaves blow in there. It's just my stuff. I had someone come in and steal $1,000 worth of tools. Is the main reason I want a garage, so that I can secure. My wife wants me to have a garage so that I can. That's another important factor in this. To protect all that stuff, and of course the carport's going to be gone at that point. It's an eyesore. It's falling down, and that red building, it's coming down as well if I get permission to build the garage. That's pretty much it in a nutshell.
Okay, this is David Taylor, and I have a question for codes, or maybe explanation that we've already that I've discussed with codes when I was reviewing the cases. You're asking to build a 1,040 square foot structure. Codes allows 750, and as I understand it from codes, and this is a question to codes, not the applicant, to help basically for the benefit of my memory and also the rest of the board, is that the 750 limit that you can build an out structure 50% of the house size or 750, whichever is greater. So if he had a bigger house, he could build a bigger outbuilding, and that he wants to build 1,040 square feet, and zoning would allow him 2 750 square foot structures, just not 1,000 square foot structure. Is that right, Lisa, that based on our conversation?
That is correct. The zoning allows for you to build up to 750 square foot or 50% of the footprint of your house at a reduced setback. So it's 50% of the house and rear setback requirements in most cases. So in this case, if he wanted to build 2 smaller structures, the first one would be allotted at the reduced setbacks. The second structure would be at the house full setbacks of the 5-foot side and 20-foot rear, up to a maximum of 40% of the lot area coverage for all buildings on the parcel.
Okay.
Does that make any?
Yeah.
Is that clarify?
Yeah.
Okay.
It does. I just, like I said, to me that was helpful to know where we are, and I know that there have been times when the house size was viewed as as a potential hardship to warrant allowing a larger out structure. So I just wanted to make sure that I remembered all that correctly.
Yes.
Are there questions from the board? Mr. Kilgore, the only question I have is that, and I'm not sure how much of that you heard, but it sounds like you could build two structures. Is there a reason you'd prefer the one structure over two? Is there an existing pad? Is there other reasons that the one larger building makes sense rather than the 2 smaller buildings?
Yeah, it really is. Aesthetically, I'm trying to keep it roughly it's going to be a little longer than the carport that I have back there now, but I'm trying to put something in that same location and leave the rest of my yard free. I don't know if that makes sense to you.
It does. Are there trees and other plantings in the yard, or?
At this time, there's not. I'm kind of waiting to see. No is the answer to that question. There's not any trees right now in the yard.
Okay. Any other questions from the board? Did you have anything else to add, Mr. Kilgore?
I just want to thank you guys for hearing this case.
Okay. With that, we will close the public hearing. And thoughts from the board? Ms. Carbonek.
I think I followed what you said earlier about he could build 2 structures that would equal the same square footage of what he's proposing, is what I think I heard earlier.
Yeah, and actually he could build 2 750 square foot structures for 1,500 square feet, and yet he's asking to build, kind of split the difference in one structure.
I see.
Yeah, so I mean, he's asking for 1,040 square feet, which I think he could build by right if he had a 2,000 square footprint house, but he doesn't, and so yeah, that's where I was saying there's sometimes when that house size limitation, To me, I'm empathetic to the request because of the existing pad and wanting to just kind of extend that further back. But
Yeah, I also see that he's taking down the existing shed and the existing carport. So he is removing from structures already there and kind of consolidating into one area,
right.
Which also makes sense.
You're right. Ms. Davis?
I was going to say that I agree with Ms. Karpanek and with you, Mr. Chairman. It seems like, and thank you for that background and for asking that question. It seems like what he's proposing is already sort of a compromise. So, I mean, and I think he can make the argument that he has a hardship in light of what's happened on his property, and he's sort of doing this for security reasons as well. So I think he could ask for more. I think he sort of already met us in the middle. So unless someone else, I'm still listening. So unless someone else had something they wanted to point out, I'm sort of leaning towards supporting this.
Okay. Mr. Newton?
I want to note that, the councilman for his district did weigh in. He was going along with this plan. So I'm going to make a motion based on the hardship of his house footprint being kind of smaller than the rest of his area, and the existing structures and the kind of events that have happened on his property, that this request be approved as long as the two existing structures are demolished. I just want to make that part of my motion.
Okay. There's a motion, Mr. Lawless?
I'll second the motion and want to compliment him for doing exactly what his wife wants him to do. So, Mr. Kilgore, you're a smarter man than most. I will say that for you, sir.
All right. So we have a motion. We have a second. Is there any other discussion? Okay. We'll call the question and start with Mr. Newton.
In favor.
Mr. Lawless.
In favor.
Ms. Davis.
In favor.
Ms. Karpanek.
In favor.
Mr. Pepper.
In favor.
I'll vote in favor also. That motion passes unanimously. And best of luck to you, Mr. Kilgore. Next case.
Board, this is Jessica. It looks like the appellant for the next case has dropped off, and I'm trying to get in touch with them to see if they're having. But could you move on to case 249, and then we could circle back around with 237?
Okay, Mr. Wallace, do you have a question?
No, sir, I'm sorry. I didn't take my hand down.
No worries. Okay, so we will move to case 249.
These next three cases are short-term rental cases. I will introduce the case, and then Mr. McBroom will speak on behalf of Codes to make the presentation, after which point the applicant will speak. Case 249 is an item A appeal challenging the zoning administrator's denial of a short-term rental permit. The appellant operated after the issued short-term rental permit expired within an AR2A district. Mr. McBroom will now state the case detail.
Good afternoon, Board. Bonnell McBroom, Property Standards, Codes and Building Safety. On April the 11th of 2016 was the first online activity for the advertisement. On October 27th, 2017, host cease and desist letter was sent. On November 3rd of 2017, estimated delivery of the letter. On April the 11th of 2016 through November the 3rd of 2017, there were 54 document stays, 2 of which occurred in November of 2017. January 5th of 2018, a warrant was requested by zoning examiner Robert Osborne for advertising and operating a short-term rental property without a permit. And on January 17th of 2018, the warrant was issued. February 14th of 2018, the environmental court dismissed the case with just court cost. January 8th of 2018, the BZA appeal was filed. On March of 2018, there was 1 documented stay. On May 10th of 2018, BZA appeal result was able to apply as soon as the hotel taxes were paid. March 8th of 2019, the SDRP application was filed. On April the 10th of 2019, owner-occupied short-term rental permit was issued. On March 23rd of 2020, Inspector John Feltz sent a notice of violation for permit number not displayed in the website advertisement. On April the 11th of 2020, the permit expired. On August 11th of 2020, Campbell Padgett sent a notice of violation for advertising and operating with an expired permit. There were two document stays in October of 2020. October 19th of 2020, BZA appeal was filed. October 22nd of 2020, ads were removed. Ads were reposted and removed several times between October 2020 and January 2021, with the final removal on January 5th and 6th of 2021. There were two documented stays in November of 2020, and there were no documented complaints reported on the property.
Are there any board questions? Room? All right, thank you.
The applicant will now address the board. Please state your name and address and then present your case.
Okay, I'm Gary Stump at 6114 Licton Pike, Goodlettsville, Tennessee. My wife and I are 70 and 72 years old, and the only significance of that is that I simply forgot about the short-term rental permit. We renewed our business license, and we have routinely submitted our sales taxes collected monthly as required. Apparently, Nashville government notifies people that are late on renewing their short-term rental permit via email. Nashville government had incorrectly entered my email, we discovered later. We finally received the first letter around September. And then unfortunately, again, we accidentally called the department that issues the business license, and we're told everything was okay. Obviously, we called the wrong department, and I apologize for that mistake as well. Next, we received a phone call in October, and were just shocked to discover what had happened. We immediately addressed the issue, and after completing the other required procedures, I'm here to talk to you today. This was simply a memory problem, and we have consistently paid the sales taxes. We are retired, and this income means a great deal to us. We humbly request we be allowed to operate as soon as possible. Another thing in terms of as soon as possible, I submitted everything to be on the previous meeting that you had, and they didn't process that on a timely basis, so I was delayed a month in even making this appeal. We will determine how to handle this going forward so this never happens again. As I understand, this has to be paid in person. It would be great if this could be set up to pay automatically. I would love to be able to do that.
Mr. Stump, this is David Taylor. Was curious to know this latest time when you got the letter in October, did you stop all rentals from that point on, and have you rented it since you got that letter?
We took down the advertising as soon as we were notified.
Okay. Did you rent it at any time between the time?
We had one short reservation already been made, and I'm sure you're familiar with Airbnb and vacation rental owner. To cancel a reservation is a big deal with them. So we honored that one short, I think it was 2 or 3 day rental.
Okay.
That had already been booked.
Okay. And then do you own this, do you live in this home, or do you have, do the guests stay in the home while you're there, or do you vacate?
Yeah, we live in the home. What we rent out is a full basement. I had finished it for my mother when she could no longer live on her own, and after she passed away, we years later decided to do the short-term rental permit.
Okay. Are there questions from the board? Mr. Stump, did you have anything else to add?
No, sir. Like I say, it's primarily just a memory issue, and again, them entering the wrong email address. and I apologize. It was nothing done deliberately. Like I said, I gladly paid the sales tax each month. I thought I was doing everything I was supposed to, but obviously was in error.
Okay. Mr. Lawler.
Right. I want to make sure that I understood what the applicant or the appellant said. Mr. Stumpf, you said that you stopped advertising around October, but yet our report shows that there were repostings.
Oh yeah, on that I can explain that. I think it's on Airbnb. You can pause it for a specified period of time. And again, as I mentioned earlier, I was originally supposed to be scheduled on your previous meeting. And I don't know what the delay was up at the Nashville government, but they didn't process the paperwork in time. So it came back online and I immediately put it back on vacation. In other words, I was anticipating already been up. And with them, you can pause it up to a given date. So when I realized that it reposted, I immediately shut it back down.
Thank you, sir.
You're welcome.
Any other questions? Okay. Mr. Stumpf, did you have anything else to add?
No, sir. Again, I appreciate y'all's time.
Okay. Jessica, were there any calls in?
There were not.
Okay. Then we will close the public hearing. Thoughts? Ms. Carpenter.
Well, I appreciate all the testimony, and but still there were some stays after the applicant was notified. So I see that as a little bit of a harsher penalty than just the time served.
Did you have a thought about that?
Mm-hmm. Yeah, I was thinking, my thought was a March 1st, they could be able to apply for the permit again. And Mr. Lawless has something to say, so I won't make a motion at this time.
Mr. Lawless?
Well, if she made a motion that said March 15th, I probably would have seconded it, but.
Okay, I can do that. I will move that the zoning administrator did not err and that the applicant be able to apply for the permit on March 15th.
I'll second that.
I have a motion by Ms. Carpenter, a second by Mr. Lawless. Is there any discussion on that motion? Then I will call the question and start with Ms. Carpenter.
Sorry, I am in favor. Had a little trouble getting to the microphone.
No worries. Mr. Newton?
In favor.
Mr. Pepper?
In favor.
Mr. Lawless?
In favor.
Ms. Davis?
In favor.
I'll vote in favor also. That motion passes. The applicant may apply for a permit on March 15th and note that there is not a permit now and should cease all rentals until he has a permit in hand. And next case.
Next, we'll review case 2021-017. Mr. McBroom will speak on behalf of Code to make the presentation for this case located at 5604 Morrow Road. Its applicant is filing an item A appeal challenging the zoning administrator's cancellation of the short-term rental permit. The appellant changed ownership while the short-term rental permit was active within the CS district. Mr. McBroom will now make his presentation.
Bonnie McBroom, Property Standards, Codes and Building Safety. November 4th of 2019, Type 3 not owner occupied STR permit was issued. On April the 30th of 2020, the property transferred by warranty deed from Colton and Catherine Ashby to 5604 Morrow Road Trust. On October 26th of 2020, the transfer of the property came to the attention of the Metro Zoning Department. It was forwarded to zoning examiner Robert Osborne for review. October 28th of 2020, Mr. Osborne confirmed the transfer and requested a notice of invalid permit be sent by the zoning administrator, Mr. John Michael, to the new owner, as well as a copy to the property manager on file on the permit, which is Hey Y'all Nashville, Dorinda Dawn. On November the 3rd of 2020, the invalid permit letter was sent. On November the 30th of 2020, the BZA appeal was filed. There were no advertisements identified for this property by host compliance or by independent research, and there are no documented complaints on the property.
Okay. Any questions for Mr. McBroom? All right. We'll hear from the applicant.
The applicant may now address the board by stating your name and address and presenting your case.
Hi, good afternoon, board. Thanks for giving me this opportunity. My name's Colton Ashby. I'm the owner of 5604 Morrow Road. I'm basically what had happened is that because of my occupation, I'm in California here as a firefighter, and with the new pandemic and everything else, my wife and I thought it would be smart to get our affairs in order, get our will up to date, and put our properties in a trust. So that's what we did. And we put this property at 5604 Morrow in a trust and in our will. It's not, what we're appealing is basically that it wasn't a change of ownership. So we didn't change ownership. We just put our property into a trust. So we did not understand that that was a violation of the short-term rental permit. And that's basically what we're appealing, that it's a violation because it's a change of ownership, because it's still us, it's still our property. We just put it into a trust for our protection. Immediately upon finding that we didn't even know that we had violated it until we applied for our new short-term rental permit to update it. And then we were notified by the city that we're in violation. And we filed the appeal, and we spoke with our property manager, and she put together the letters and the signs and put forth the appeal on our behalf. And so I guess what I'm asking is that we just forego the year that we have to wait for a short-term rental permit. It's already been we've been hit pretty hard with the pandemic that we didn't have very many people staying at our place anyway, and it's creating a bit of a financial hardship. And we just came to you hoping to appeal to you and let you know what our position was.
Okay. I have a question for either Ms. Minton or Mr. Michael about kind of what we're doing here, because just to make sure, I mean, it sounds like that there was a change of ownership, and which is what's being appealed, but it sounds like also that the applicant had mentioned a year wait. So is there an element to this which is, renting after the change of ownership? And I guess the other piece of that is the applicant in an address where they could apply for, the type of permit they're applying for?
Mr. Taylor, this is John Michael, the zoning administrator. The last question is one where I'll ask Mr. McBroom to respond with regard to the type of permit, the date of issuance, and therefore which law will guide when they do get the ability to reapply, whatever that date may be. So put a pin in that for the moment. We'll ask Mr. McBroom to be able to address that in a moment. As to the first two questions, I think that first there's kind of a if-then scenario. One, the board determines whether or not there was an error made or an illegality, misapplication of law when the zoning staff determined that this change in ownership, and the board knows its track record with determination as to whether or not placement into a trust is legally a change in ownership. First, you'll decide whether or not that was an error. And if so, then you'll overturn the action of the zoning staff, and the permit will effectively be reinstituted. If, however, the board follows its overwhelming precedent of several years and upholds the action of the zoning staff with regard to this change in ownership, then it goes to the second question of, okay, fine, change in ownership. Then the board looks at whether or not to reduce the 1 year wait before a new application can be filed with regard to the, not only the change in ownership, but to your point, Mr. Chairman, the subsequent rentals that took place after expiration. I will also always note, and this, to whatever extent it applies here is fine, but I always like to remind the board, we in the code staff do not tax people, so to speak, not literally tax, but hold them accountable for actions such as rentals or advertisements that took place between the date of a change in ownership and the date on which we, the code staff, notified them of the permit's invalidity. So if, for example, Mr. Chairman, you had a permit that on January the 1 became invalid because of a change in ownership, code staff only found that and notified you on February 1, we would not hit you with violations for rentals, advertisements, or other related activities from January 1 to February 1. If, however, after the notice goes out on February 1 that permit is no longer valid, you just rented the heck out of it throughout February, March, and April, then we would clobber you unmercifully. What questions remain?
Mr. Lawless.
I'm looking at my package, and did the applicant actually sign this appeal? I just want to make sure we've got everything as it's supposed to be. And Lisa, I'm going to probably pose that question to you because mine's blank. I just want to make sure if we do something, we're doing one way or the other. And then I do have a question for the applicant. When you permit me, sir.
He's also signed page 4 electronically. But.
Mr. Lawless, this is Bonnie L. McBroom again. The application for the appeal was signed on page 3 and again on page 4.
Thank you. And mine I couldn't read it, and I just wanted to make sure we were where we were supposed to be legally while we still have these. And I'll wait for you to open up questions, Mr. Chairman, for us to the applicant.
No, that's fine. That's fine.
Okay, if I can ask the applicant this, or the appellant, I guess, did you have an attorney helping you when you were transferring this property and redoing your will?
Yes, sir, I did.
Okay. Did you had an attorney in California helping you, obviously?
The attorney is in Austin, Texas.
Oh, okay. All right. So you did have representation?
Correct.
And he didn't tell you that transferring real estate from your personal names into a trust was a transfer, at least under Tennessee law?
Correct. He did not tell me that.
Okay.
The first that I was aware that there was anything that I had violated was when I went to reapply for a short-term rental permit, and it was denied. That's when I first found out.
Are there any other questions for the applicant? I'm sorry.
Mr. Chairman, if I may, you had asked the question about whether this applicant would be able to obtain a permit.
Yes, sir.
Being it's not owner occupied. This is a CS zone, and therefore it is still available with non-owner occupied permits with conditions. And I don't have the specific conditions that would apply basically to this particular zone. But in any event, the permit is still available. Now, just in general, sometimes due to the state law and the advent of 608, depending upon when the permit was obtained, it will be governed by the ordinance in effect at that time. So that would be an individual case-by-case selection. But in this case, it is still open for non-owner occupied permits.
Okay. Thank you, Mr. McBroom. Is there, does the applicant have anything else to add at this point?
No, sir. I'm just here for any questions you might have.
Okay. Any last questions from the board? Seeing none, I will close the public hearing. Yeah, I personally don't have an issue with allowing the applicant to apply sooner. And the zoning administrator is correct in that we have pretty much overwhelmingly recognized that putting changing the ownership from a personal ownership into a trust is indeed a change of ownership, even though the trust or the LLC or what have you is solely owned by the two people or one person that had previously owned the property individually. And it, as a non-lawyer, it doesn't always make sense, but we know that's the legal way to look at it. And so to me, I think that they did change the ownership, but and I don't know that we've had, I don't remember from Mr. McBroom if the testimony was that they actually did rent it from that date on. But assuming that happened, then I would still be willing to allow them to reapply as soon as they possibly can. I would say Monday. Oh, I'm sorry. You know what? I'm getting a note to say to make sure we ask Jessica if there are callers to confirm that there are no callers in before. And if there are, then I'll reopen the public hearing.
There are not.
Thank you. We're going to get this, we're going to perfect and smooth this whole online process about the time. Hopefully we get to meet in person again, but I apologize for that. But no, my leaning is to allow them to apply on Monday, assuming that the law that they were under would allow them to do that. Mr. Lawless?
Okay, just, you know, I don't mind leniency in some respects, but, and I'm going to go back to the technical comments that I'm making before. This is more for the lawyer types on this. The owner of the property is not the appellant. Technically, I don't think this case is properly before us. I mean, I guess we can go the equity route and say, well, we can just assume it, but it's the trust that's the property owner. And if the trust is the property owner and not the Ashby's individually, who's properly before us? That being said, my only comments, have we closed the public hearing yet?
Yes.
Okay. My comments sort of are, you've got an individual and his wife that own the property. They're doing smart by protecting assets, and I always compliment people on that. But they had a lawyer, and you know, maybe they need to talk to the lawyer or his carrier on what they did, because what they did didn't comply with the law. And it's our job isn't to disregard the law that's out there, is to try to follow it, but follow it with a certain humanity attached to it. And I'm having a tough time with this one, if you can't tell. So, I mean, I want to help as much as I can, but I don't think you can sweep it under the rug.
Well, this is David Taylor again. I mean, I appreciate that, but I mean, we've had plenty of Nashville lawyers that have done the same thing that you know, appeared before us that really had no clue about this particular law, and that may be the lawyer's problem and between them. But I guess what I'm saying is, I guess, you know, they transferred the trust. They still managed it through the fact that they've always done it.
No, I mean, their testimony, David, Mr. Chairman, not to disagree with you, he said our property manager, and they're off-site, so that they weren't. They had, I mean, they did what a prudent person would be, and I'm not criticizing them. I'm just simply saying that aside from the legal technicality of who's properly before us, you know, they've got all these people helping them, and they're getting really poor advice. And the rules are there for them to follow. I know I'm being a little hyper technical today, but and I'd like to help him, especially considering what his profession is. Believe me, but I'm just being a little.
Well, and I understand that, and that's fine. I guess to me the questions that's before us are one: did they change ownership? Did the zoning administrator get that correct, and they changed ownership, which I haven't heard, and others may disagree, but the board has pretty consistently said, yeah, they changed ownership by putting it in a trust. And if that's the case, then the only question we have then is, when would they be eligible to reapply, assuming that they rented this after they changed the ownership? And we heard from the zoning administrator say that, it's that the way they have administered this is the offense really starts with notification, and we really haven't seen. I don't think we've heard direct evidence that they rented it after notification. So we may just say that they didn't rent it and there's no offense. But assuming that there is an offense, then it's what period should they wait? And that's really the only question that we have to ask is, what's the waiting period in my mind? So, I mean, I get all the technical pieces, but I don't see that when it boils down that it's different than what I was, then should they wait or not wait based on their behavior after they were noticed, which I don't recall any testimony saying that there was any flags in that behavior. Mr. Pepper?
Well, I will echo what you said. I think that there's no question that the zoning administrator did not err. The question is, do we reduce the penalty from 1 year? I think Mr. Lawless also has a very good point, which is the application is not the name of the owner. And I think maybe a way to remedy that is for whatever motion is made to make sure that we make clear that the relief is being granted to the current owner and not to the applicant, because the applicant is not the current owner. So those are my thoughts. I don't know what period of time the board thinks is appropriate to reduce the 1 year from, if any. I would like to hear from others on that. Thank you.
Mr. Newton?
I would think a short amount of time, if any. I think Monday is fine, quite honestly, to reapply. I see this as being, as not a lawyer, I see this as being a very arbitrary technicality that it has no real world kind of practical infraction, essentially. Maybe that's just me not being a lawyer, but I don't see where this person has kind of erred, other than maybe not getting the full good advice of a Tennessee lawyer.
This is Ashanti. David, can you hear me?
Yes.
Mr. Trent. I'm sorry I didn't raise my hand. I agree with you about the question before us, and I think we have been consistent in the past. In this particular case, there's nothing about the facts that make me feel inclined for like a Monday application. I'm not saying it should be 6 months. I'm not saying it should be 3 months. But I think for me, it should be, this is a business for these people. And I think that, they don't live in town, which is fine. And then, and because of that, maybe that's why this happened. And I just think that there was a point to the law. The point to the law was because at the time, there were a lot of transfers going around to evade the law. And so there's a point to the law, and sometimes it does lead to a harsh result. But I do think that there's a point. And I guess in my mind, Monday isn't very meaningful. So for me, I think it should at least be a couple weeks for me to feel good about it. But, I'll listen and defer to the wisdom of this board. And if everyone else feels like it should be sooner, I understand that. So that was just my 2 cents.
Okay. Mr. Lawless?
Well, Ms. Davis, was March 15th in your range of an appropriate time frame?
Yeah, that's about 2 weeks. Yeah.
No, you said
3 weeks, yeah.
March 15th.
that's 6 weeks.
Is it 6 weeks? Today's the 21st. That's 6 weeks?
No,
Sorry.
No, March, the Ides of March. I keep coming back up to the Ides of March. Or were you thinking more like Valentine's Day?
I was thinking more in February. I'm sorry.
Okay.
More in
So if you were saying Valentine's Day, that would meet your criteria.
Yeah. And say February 15th, since the 14th is Sunday.
Yeah. So after, yeah. So is that your motion, Ms. Davis? Because I would second that in a heartbeat. Okay.
Yeah, I'll make a motion then that the zoning administrator did not err in this case, and that the applicant be allowed to reapply for their permit on the February the 15th.
And I would second that.
Ms. Davis, this is Mr. Pepper. Could you amend that to say that the owner be allowed to apply? Not because I think we've got the wrong applicant as Mr. Lawless.
Yeah.
Thank you, Mr. Pepper. I'm sorry. I do accept that amendment.
Okay, we have a motion and we have a second. Is there any other discussion? Mr. Lawless.
Point of personal privilege, and that is your lawyers were acting like lawyers again.
All right.
We can't help ourselves.
Well, that's right. The rest of us just sat back and let it go, right?
And now we know why the world is so screwed up.
All right. So any other discussion on the motion? All right. Well, I'll call the question. Start with Ms. Davis.
In favor.
Ms. Carpenter?
In favor.
Mr. Newton?
In favor.
Mr. Pepper?
In favor.
Mr. Lawless?
In favor.
I'll vote in favor also. That motion passes. And we were waiting on the last case, number 237. Is the applicant back with us, Jessica?
Yes, the applicant is present. The final case is case 2021-237. I'm sorry, 2020-237, located at 288 Clear Lake Drive. It's an item A appeal. Let me get the correct slide for you. Item A appeal for denial of a short-term rental permit. The appellant operated after the issued short-term rental permit expired within an R10 district. Mr. McBroom will now go over the details of the case.
Bonnie McBroom, Property Standards Inspector, Codes and Building Safety. The February 12th, 2017 through August of 2018, advertised and operated a short-term rental property without a permit. 53 documents staged during this time. April the 3rd of 2018, a cease and desist letter was sent by Host Compliance. On April the 9th of 2018, estimated delivery. April the 12th of 2018, 2 Airbnb ads were removed and 1 Booking.com ad remained posted with calendar blocked. Ads were reposted and removed numerous times. April 27th of 2018, a BZA appeal was filed. Documented stays were after the appeal was filed in 2018, 3 in May, 2 in June, 1 in July, 3 in August. June 21st of 2018, the appeal was deferred, and again on August the 2nd of 2018. August 16th of 2018, the appeal hearing opposition of council members Karen Johnson and Tanaka Virtue and many neighbors. The BZA upheld the 1-year prohibition on applying for a permit. May the 9th of 2019, the permit application was filed. On June the 12th of 2019, the owner-occupied permit was issued. On September the 6th of 2019, a warrant was requested for advertising and operating a short-term rental property in intent. On October 23rd of 2019, the Environmental Court ruled that a permanent injunction would be placed on the property against advertising and operating a short-term rental property in intent. On June 13th of 2020, the permit expired. September 9th of 2020, notice of violation was sent. On September 22nd of 2020, a BZA appeal was filed. And then on September the 23rd of 2020, the ads were changed to a 30-night minimum. In November of 2020, however, there were 2 documented stays in a 1-month period, as evidenced by 2 November 2020 reviews on the Airbnb advertisement. The link for the advertisement is included in your package. Neither Metro Records nor Host Compliance has any documented complaints on the STRP at the property. However, Councilmember Porterfield has submitted several of her constituents' complaints, which should be a part of the board's packet.
Any questions for Mr. McBroom? Okay.
The appellant may now address the board by stating their name and address and presenting their case.
Can you hear me?
Yes.
Okay. Yes, my name is Rochelle Rule, and I live at 288 Clear Lake Drive West, Nashville, Tennessee, 37217. And I just heard the gentleman before, and wow, that was a pretty long list. But I would like to, it was a very stressful situation back then. I mean, they had literally put us on the news, and we went through the process and we got permitted, and we were very excited that we had this huge ordeal behind us, and we were just ready to go on. And so, you know, we had our permit, and I put it up, displayed it. My Airbnb, or my short-term rental, is upstairs in my house, and it's separate from our living area. So I put it upstairs in our house, and I displayed it for our guests to know that we were legit. And I was super excited about 2020. We had bookings all the way through, I don't know, March, April, May. And when the COVID hit, everything got canceled. And our short-term rental property is the way that we supplement our income for our business. We have a business, a food manufacturing company that we've been trying to get off the ground for 5 years. And so when everything canceled and the food business also was struggling financially because vendors weren't paying, we were just having to pivot. And I was in a pretty much of a turmoil. We'd just gotten through the tornado, and then the pandemic. And then when they shut everything down, my son was a senior in high school, and I was trying to get him online. And I mean, the list it was just chaos. And I didn't even think about the permit. I displayed it upstairs, and I didn't, you know, it was March when everything canceled. And so we had nothing for months. And then in sometime around August, September, things started picking up, and I was pretty excited about it, and I wasn't thinking anything about it. And I came home one day, and there was a violation on my door. And I mean, my heart sank. I'm like, why? What happened? What did I do now? And I immediately pulled the permit. You know, I looked at the violation. I immediately emailed Jessica. I'm like, you know, what happened? I mean, I'm assuming, because then I went and, you know, I ran upstairs and looked at my permit, and I'm like, oh, darn it. You know, look what I did. And my husband was livid at me because we had just gone through this. He went through it. And I mean, he went through HE double hockey sticks from that previous one. So, you know, he looked at me like, this one's on you. and I emailed Jessica, and Jessica forwarded me to Mr. Fargett. And I'm like, what do? I can pay the permit. I did not intend to not pay the permit. I mean, I've been paying the taxes. I've been doing everything right. He said, you know, all I can do is appeal. And so there were some bookings. I mean, I had, there were 2 in November. And if I canceled them, you know, it goes against our, I guess you could say, rating. And one of them was a family from California, and they had, like, you know, all these kids, and I hated to throw them into a mess. And
yeah, ma'am, this is David Taylor. I have a question for you. You said that you had 2 in November, and when did they book those?
They were booked like, I mean, right around August, things started coming back.
So you knew this was after you'd filed for your appeal, and you also knew that it was illegal for you to advertise as a short term, so you advertised as a 30-night minimum stay, which you certainly are entitled to do, but then you took less than 30-day stays. That's just what you just told me. Is that correct?
No, sir. I didn't know.
That is exactly what you just told me.
No, I didn't know that it was a violation until mid-October when
ma'am, then why did you change the ad on September 23rd to a minimum of 30 nights? How did you know to do that, or why did you do that?
You're right. That was when I got that notification.
Okay.
The day that I emailed Jessica was the day that I found out that I had a violation.
Okay.
And yes, I did change it to 30 days. I mean, I was desperately trying to, you know, financially stabilize.
Okay. Okay. I'm sorry. Are there questions from the board, Mr. Lawless?
Well, I'm going to ask Mr. Taylor, since it was your line of questioning of the witness, can I sort of get a synopsis? Because I've heard 2.5 or 3 stories now. I just want to know what you do, what you know, and when she did it, if that's possible. And I guess I'm relying you, Mr. Chairman, probably more than anything else, because I got lost somewhere in her explanation.
I apologize. Can I rephrase it? Maybe summarize?
However you think best. I tried to follow it, and I actually tried to diagram it, and I got lost. So I'm sorry, ma'am.
Okay. What happened is I had no idea that there was a problem at all until I came home and there was a big red violation on my front door. And that was around, I think, September 19th or 20th. I'm not exactly sure what the date is. But then what happened is I immediately emailed Jessica, and she forwarded me to David, Mr. Forgot. I can't remember his name. And he said all I could, because I was begging. I'm like, please, sir, I did not intend to not renew the permit. I had from March to that date, I had been going 100 miles an hour, just trying to keep everything smooth. And then I came home and there was that violation, and my heart sunk. And I immediately called Jessica, and I'm like, can I go renew it now? And on the violation, it said I had till like October the 9th to renew the permit. And so I emailed Mr. Forgot and said, you know, it says October 9th. I have until October 9th to go renew the permit. How can I do that? And he came back and said that I had already violated it. It was too late, and that I had to appeal. And when I first did, I went to long term because I didn't think I could go through the whole process again. I mean, it was the time before was pretty hard. And I know I understand. I mean, I had just gone through the appeal process. I had just waited a whole year. I mean, I was so excited, and I went and put it up on my wall upstairs, and I just totally forgot. And that's all I can say. I didn't try to just not pay the permit. Everything canceled for months. And then right around August, things started picking back up, and I was excited, and I came home, and there was a notice on my window, on my door. I didn't get it. I didn't get an email. I didn't get a notification. I didn't get a reminder, which is not anybody's fault. It's my fault. I should have written myself a note because I never intended to lose my permit ever, ever, ever again, and I did.
Okay, so I'm again, and it's me that's probably having a difficult time understanding it. So you received your violation notice in September. You contacted Jessica. You sent her an email. You decided you were going to go long-term, which is 30 days or longer.
Yes, sir.
But yet you had people come in, and I think this is where I might have gotten lost when you were responding to Chairman Taylor's questions, but then you had some folks come in November, and you let them have a shorter term than that.
Yes, sir. And
you had multiple tenants, but you knew that you had to be long-term at that point. Am I misstating anything here? And I'm not picking on you. Please understand. I'm trying to understand your explanation.
Well, from I had bookings that were already booked, but when I got that violation notice, and if I cancel, then it goes. I mean, it's kind of like you're either messing up your ability to use the platform, or you're messing up your ability to,
So you made a business decision to violate the short-term rental, long-term rental regulations, as opposed to deal with violations under your agreements with Airbnb or wherever. And I'm not judging you right now. I'm just making sure I understand.
Sir, there were, I think, 3 canceled. I mean, there were 3 bookings after that, and I allowed them to come. Yes, sir, I did.
Okay, thank you. I yield the floor back, Mr. Chairman.
Okay. Are there any other questions at this time for the applicant? I know that there are some callers waiting to speak. Any other questions at this point? Seeing none, does the applicant have anything to say? You'll have time for a rebuttal, and you'll have time to talk after we hear from the callers. Is there anything you want to say before that?
No, sir.
Okay, then we'll turn this over to the section where we hear from.
Appellant, you're going to have 4 minutes and 55 seconds remaining after the people in opposition speak.
Okay, thank you.
Do we have those callers?
Here.
Hello, caller, you ready?
Yes, this is Doug Goff, Doug and Naomi Lee. Property owner is at 108 Islander Drive, Nashville, Tennessee, 37217. Within a 1,000 feet radius of the Clearwater short-term, the Clear Lake Drive short-term rental. Are we still there? Hello?
Yes.
Okay, we broke up there for a second there. Okay, should I go on? Wouldn't mind.
Yes, sir.
Yes, for some reason, I mean, it's cutting in and out. Okay, now, okay. We are challenging the appeal from Shell Rule, from Martin Rule, and okay, it just cut out again there. Okay, could you hold on just a second? I'll turn off this one.
You're just fine.
Okay, now, okay. We're challenging the appeal that was filed by Shell Rule and the half of Martin Rule for the reinstatement of the above usage of the property, so the now use of the property. We understand that the applicants are seeking reinstatement of the permit that was denied sooner. And this is something that the neighbors are really confused about, the property owners. That it says that sooner than 1 year of last operation. The biggest question that has been through the years, 2018 to the present, what do they consider that for last operation? We have continued to see cars parked in their neighborhood. And
Sir, your time is up. Your 2 minutes has expired.
Okay.
And sir, we have your opposition on record, and we have to move to the next caller.
Yes. Okay. Thank you.
Is there another caller?
Yes, sir.
All right.
Caller, you're ready.
Hi, my name is Leslie Bohr, and I reside at 109 Islandia Drive, Nashville, Tennessee 37217. And I'm calling in to oppose the Airbnb that the applicant has applied for, just due to the fact that I feel like they cause, with having them have the Airbnb, there's a significant amount of traffic that they bring into the neighborhood. Hello?
Yes, ma'am. I can hear you.
Okay, great. My name is Leslie Bohr, and I live at 109 Islandia Drive, Nashville, Tennessee 37217. Can you hear me still?
We sure can.
Yeah.
Okay, and I'm calling in to appeal the applicant's request for the Airbnb. I live right around the corner from their residence on Islandia Drive, and there have been numerous times throughout the year where they've had numerous renters come in to the point where they don't have enough room in their property to park, and they've actually pulled their cars down on Islandia and parked in front of our houses. We have tried to talk with the neighbor about this over, I guess this started back in 2018, but they have yet to make any attempt to come to us to get our concerns, to figure out how they can work with us on this, and it just continues to go. I did hear the applicant state earlier that I'm not sure, I thought I heard her say that she didn't think that she had any rentals over the summer, and that's falsification. I actually had a conversation with one of the renters that was there over the 4th of July weekend that actually parked on our road. So I feel like I'm not opposed to Airbnbs, but I feel like with these particular individuals, they don't try to work with us as neighbors. There's a lot of traffic coming in and out. There's a lot of disturbance from their property late at night. As well, which disrupts some of the neighbors across the street from me that back up to them.
Your time's up.
In opposition.
Okay. Great. Thank you, ma'am. Your time is up, and from the next caller.
Give us a second.
Chairman Taylor,
Yes.
can we just note for any callers that it's going to be delayed on your TV, so go ahead and mute that when you're hopping on the call.
Okay.
Yeah, I was noticing that also. It was interesting to hear the feedback.
Caller, are you ready?
Yes, this is Richard Beals. I live at 108 Arlandia Court East. I had sent in some information to our council lady, Ms. Porter, and some photos of the cars that are parked. There's actually in this picture that is viewed on TV right now. It's an older picture because they have put gravel beside the adjoining house there, and now they have two driveways. Both of those driveways are in the pictures that I took on January the 9th, are full of vehicles and trailers, and there was cars parked in the yard and on the street. And of course, I'm opposed to this. I'll put that out there. But many of the cars I've noticed that are parked there are either rental cars, like from out-of-state tags, or they're tourists. So if you can look at the map, you can see that there's a slight turn in the road there. If you're coming from the top of the picture toward the bottom of the picture, that's just over a rise. And there have been cars struck that are parked by the street there. If you have to go around these cars, you will foul any traffic coming from like the bottom of the picture toward the top. It's kind of a traffic situation. You also never know if somebody's going to step out from between the cars. But also I noticed, and in the pictures that I took on January the 9th, that the zoning sign was put down in the middle of the yard, and there were cars parked on the street to where you couldn't see the sign. So I don't know if there's anything to that or not. But
Sir, your time's up.
All right, sir, we've noted your opposition, and your time is up, and we will ask for the next caller to be queued up.
We have the councilman online.
Is this Councilperson Porterfield?
Yes, sir.
Mute your television or your computer.
Wonderful.
Oh, yes, ma'am.
Councilman Porterfield?
Yes, thank you so much.
Are we
But I have my computer muted, but the feedback is still really bad, so I can't hear what you're saying. Can you all hear me?
We can.
Okay, great. Thank you so much, and thank you for taking the time to hear this case, and thank you for the work that you guys do. I know that you are now rounding the curve at 2 hours, so I will try to keep my comments as brief as possible. I am in opposition, and it's a bit frustrating for the people in our community. On the call earlier, Mr. Stump said that this was, in his case, it was a memory issue, and I wish that we were only looking at a memory issue in this case. But what we've seen is that, unfortunately, the owners have consistently chosen not to follow the rules. This became a problem for our community in February of 2017,
And in about a week, that's going to be about 4 years. So the neighbors in that community have consistently dealt with this issue for the last 4 years. This is the number one issue that I hear from people that live on Clear Lake and Islandia. Has been consistently the top issue that they complain about, has been this particular Airbnb rental. I've received multiple calls and emails about this. Neighbors have stated that it has been a nuisance, that there's often a lot of noise coming from the property. One neighbor stated that they've been woken up at 5 in the morning from noise coming on the property. The cars have been an issue. I believe that the neighbor who just spoke was explaining that they have so many cars on the property that they have outgrown the original driveway. They've now put down a gravel driveway. Well, on their Airbnb listing, they ask the renters to park on the street, and it says verbatim, please park your car along the curb of the street in front of our house. Well, what that has done is it creates a visibility issue for the people on the street. And whoever is parking on the street, they're parking their car halfway in the grass and halfway on the street. Oftentimes those cars are facing in the wrong direction. So there's been a visibility issue. There have been some fender benders over there in front of the house. We had a community meeting about this in 2018 when Karen Johnson was the council member, and I was at that meeting, and the room was packed with people that had concerns, again, noise concerns about parking, and it's very, not only is it disheartening, but it's very telling that here we are in 2021, and these complaints are still happening. The same complaints verbatim from 2018 are still happening. So I think that goes to show that the intent of the owners is not to comply with the rules. They've been given multiple chances and they have chosen not to comply. They also are advertising that you can anchor a boat on the backyard because their property does abut Army Corps property, which you are not allowed to put a boat on Army Corps property. So even in the advertisement and advertising that you can go out and build a bonfire, you're not supposed to build a fire on Army Corps property. So even in the advertisement, they are giving permission for their renters to break the rules. I would also like to bring attention to the fact that there has been a permanent injunction filed and a court ruling from October 2019. Now, that ruling was based on them operating the tents in their backyard. They had a tent in their backyard that they were advertising as an outdoor bedroom. When we talked about it at the community meeting, the owner denied it and said that he had a car under the tent and that he wasn't using it as a bedroom. However, I presented pictures from the Airbnb listing that showed that they were using it as a bedroom. So on top of everything else, historically, the owner has been dishonest with the community when presented with information from their own listing. Now, there is an injunction, so they did stop the tent, but the issues with the noise and the parking have not stopped. The appellant said that things started to come back in August, but if you look at the reviews, there were multiple stays in both June and July. So they've consistently had stays June, July, August, September, October, and there were 2 stays in November. The owner just stated, that they did allow 3 bookings to come, even though they've known since September 22nd that they were not supposed to have any more short terms. They still allowed 3 more to come. And then the last thing that I would like to say is that not only am I asking you to uphold the 1 year, but I'm asking that you start the clock of the 1 year suspension in November 2020, because that's when they had the last documented stays. We don't know if there have been stays since then, but we do know that there were short-term stays in November. So I'm asking that you actually start the 1 year in November. Now, I know that the owner said that they were, they waited their 1 year last time, but that is not true based on the information that we have. In April of 2018 is when they filed a BZA appeal previously, but they had non-documented stays from May to August of 2018, and they were issued a permit in June 2019. So they didn't have to wait a full year. They didn't have a full year penalty last time around. And my neighbors have been very vocal about wanting to make sure that they have their full 1 year penalty because they continue to break the rules. Now, several of the neighbors that have emailed and called said, unfortunately, they were not able to attend today because the notice that was sent to their home, they thought that they had to come in person. They did not realize that there was going to be a virtual call-in option, so they did ask for me to speak on their behalf. And then there were also some complaints because of the number of cars that are occupying both driveways, and there are cars that are now in front of the house as well. It's almost like a U. The sign that is in their yard about the hearing is not visible from the street. So when people are driving by, they're not able to see this sign. So we had neighbors that did not know about the hearing today that wanted to speak in opposition. But I said that I would make sure that you all were aware of all of this. So again, thank you for your time. I appreciate what you all do. And if you have any questions for me, I can gladly answer them.
Councilor, David Taylor, can you hear me?
The feedback is very bad, but I can make it out a little bit.
Well, I know that you said, that you wanted to start, the clock is in November. I know we will probably ask our code staff. I think that we can start the clock of finding a violation, and that may be today. So I'm assuming that you want the longest clock possible based on the testimony. Is that correct?
If I heard you correctly, if you can start the 1 year from today, that would be even better. Yes.
Okay. Thank you.
Thank you.
Yes, Chairman Taylor, this is Bonnell again. That does start from the date of the BZA decision.
Okay, thank you. Are there any questions for the council lady? All right, we should appreciate you.
I don't have anything else. Do y'all have anything else for me?
I don't see any hands up, so we sure appreciate you coming and talking to us today.
Okay, thank you. I'm going to disconnect and continue listening from the computer. Thank you.
All right. Mr. Lawless.
I just want to at least make one observation, and I hadn't picked up on this until the council lady was on the phone with us. Their Airbnb ad says that they are limited to 8 guests.
Right. So are you we need to hear back from the applicant?
Yeah, I can do it afterwards.
Okay, and then we can have that discussion. Okay. Any other questions for the code staff, or then and Ms. Shepherd, were there any other callers?
There are not.
Okay. Then we need to allow, I think, for rebuttal from the appellant.
Yes, can you hear me?
You have 4 minutes and 55 seconds.
Okay, thank you. First of all, I would like to say that most of the vehicles that are in the yard are our vehicles. We have a Suburban that is parked in the gravel that needs to be repaired. We're trying to pull it to Florida right now. We have a trailer and a truck, a Toyota 4Runner, because we have a food business. So we make drop-offs. We have a boat in the back. I have a 27-year-old son who has a Ford Taurus. It's a gray Ford Taurus. My other son, who goes to college, has a white 300 Chrysler, and he uses it to go back and forth to college. So I have worked very hard to organize our parking. So I have it very specified. My husband and I use the driveway. And everybody else, if they can use the gravel parking area, which is a decent space, or park in front of the drive on the street. I have never, I'm going to say, this is the first time that I have ever heard of anybody in our neighborhood saying that they came to our house and wanted to speak to us about cars. I have never had a complaint I have never had a car issue. And when somebody said there was a fender bender in front of our house, that is not true. There has never been a fender bender in front of our house. We are not, I mean, they made us sound. This is the reason why I didn't want to do this time. I almost didn't even go through the appeal, because this is what happened with this council lady, Karen Johnson, who had us on TV. So, you know, I was very leery about doing this again, because when Mrs. Porter says that we just break the rules, what rules have we broken? I do not understand what rules that we've broken. I have a boat. We have a boat. And if we want to take our guests for a boat ride, are we not allowed to do that? I mean, it doesn't hurt anybody there, does it? That's our boat. And we offer boat rides because it's something fun for people to do when they come to Nashville, to take them on the lake. So we're not a bunch of crazy banshees over there. I mean, my right neighbor, my left neighbor, my neighbor across the street, they signed for me, like saying, you know, Mr. and Mrs. Rule, we have never had any problems out of them. And if there was ever a problem, we know for a fact that they would take care of it. We don't have, we're not out of control at all. So I wished this person from 1008, 1009 would have came to speak to us. And it sounds to me like they keep talking about the cars and the vehicles. Well, I did not know they had a problem with our cars. And sometimes there is a car parked on the street, but it's not like constantly. And I have never, ever, ever had anybody park down the street on Islandia Drive. I get everybody on my driveway, in my gravel, or in front of my house. And most of these vehicles, as I said, are ours. And, you know, during the summertime, I have family that comes and visit. I have family from Florida. I mean, we have a food business. We have two businesses. I mean, we're entrepreneurs. So all of those cars are not from the Airbnb. Those people pull up in maybe one rental car from the airport. So they're just really, I mean, to me, this just got really, really overstated, or whatever you want to call it.
Well, Mr. Lawless.
Yeah. Okay, I do have a question for the applicant, and you know, let's try to make it real simple. What are the maximum number of guests that you have at your Airbnb? 8. Okay, then why is it in November of 2020, Aaron had 9 people?
He was the gentleman that I told you about that came from California. He had 8 children.
But 8 children and an adult, how many people is that?
He had 7 children and 2 adults. It was a baby.
And what's the total number? 9, but it was a baby. So you have now, ma'am, let me ask the question or make the comment, please.
Yes, sir.
So you state that you're going to have 8 guests, 3 bedrooms, 6 baths, and 6 beds and 1.5 baths. But you've just stated that he had 9 people there. So you disregarded the rules there too, didn't you?
Sir, that is my...
No. Did you disregard the rule? You can explain after you answer.
That's not a rule.
That's what you've advertised, correct?
Yeah, but that's my advertisement, and I made an exception.
Okay, that's all I wanted to know. Thank you, ma'am.
Are there any other questions for the applicant? Ma'am, did you have anything else to add?
No, sir.
Okay.
Thank you very much for hearing me. And again, I really have not intended on breaking any rules or causing such, I wish they would have come over, and if they had a problem with the car on the street, they could have come and told me. I'm very easy to deal with.
Okay. All right. Thank you. We will close the public hearing. Ms. Davis. I think you're on mute.
Mr. Chairman?
Yeah.
If I might interject, this is Bonnell again. Just check back, and I believe the permit for this property was for 3 bedrooms and 10 occupants, so they just choose to advertise 8.
Okay.
Hey, isn't it 2 people for every first bedroom plus 2 people? Or is it 2 people for every bedroom plus 4 people? Thank you.
All right, we can hear you all. Ms. Davis, did you have a... Ms. Davis?
I'm here, Mr. Chairman. I'm here. It sounded like you were going to say something to sort of crystallize.
No. Your hand went up, so the floor is yours.
Okay. I was just going to say that from my perspective, that this is a pretty clear-cut case of waiting the maximum time. There was a lot of evidence that sort of showed a pattern of behavior with the particular applicant, and even within the applicant's own testimony, both you and Mr. Lawless pointed out inconsistencies within her testimony. So I didn't find her testimony all that reliable. And given the weight of the evidence and given the weight of this applicant's history and the comments of the council person who has spoken to people who live close by to this property, from my perspective, this is sort of an easy case to sort of to go ahead and just say, they can apply in 1 year from today's date. But I'm willing to listen to the wisdom of the other people on the board. So,
well, and this is David Taylor again, and I agree. There, you would hope that in August of 2018, when you had multiple neighbors and 2 council people ask that basically say that you're not following the rules and you deserve a year's wait on applying, that there wouldn't be any behavioral issues afterwards. And normally on an expired permit, it does come down to, what is the behavior of the applicant? And, it's since the first hearing, it's been to environmental court because they were, having a tent or doing something they weren't supposed to. It's come back to us. We have another council person who's come and said that, the behavior is disruptive to the neighborhood in terms of cars, in terms of other things that they're advertising, and the fact that they admitted to knowing that they had to do 30 days or longer, but keeping the November rental. I mean, it adds up. I mean, I've been on this board since we first started hearing these cases, and it's a top 5 anyway in terms of the type of violations and neighborhood opposition and council opposition based on behavior, not just the fact that they don't want to be in their neighborhood.
Chairman, I'm sorry to interrupt you, but we've just been notified that we have gone off air. And so we are trying to get in touch with IT. Is it possible that y'all could pause the conversation? The councilwoman has even contacted us to say that they can't view it.
Okay, then just let us know.
Okay, give us just a few minutes, see if we can get something worked out.
Mr. Chairman, can you hear me? This is Mr.
Yeah, I can.
Okay, I've got to leave at 3:30, so I'm going to hang out and see if we can get back on and do a vote. But just so you know, I think we'll still have a quorum.
Yes, sir, and I think hopefully we'll be.
It looks like we're back on now.
Okay, we're back on. Do you know, Ms. Shepard, do you know when we left?
I would say when you started your recap or your.
Okay.
Just after the appellant had finished, I believe Ashanti had asked a question or made a statement, so somewhere around there.
Okay, where Ms. Davis had said that this, in her opinion, this deserved the maximum penalty from today. And just to summarize again, I had made the point that on all the cases that we've heard, and I've heard all the Airbnb cases since we first started hearing them, it really is a top 5 in terms of, if not higher, in terms of having council members oppose the first time in 2018 based on specific behavior as well as neighbors. Another council person, a third council person bringing the same type of behavioral charges again, along with many neighbors, as well as the applicant's testimony today that she knowingly rented twice in the month of November after changing her website to reflect what the law would allow her to do, which is 1 30-day rental in that time. So I'm 100% in agreement with Ms. Davis that we should find that the applicant, zoning administrator, didn't err, and that the applicant be able to apply 1 year from today. Mr. Lawless?
I assume that that's a dual motion to enforce that way, and if it is, I'll be a third on it.
Ms. Davis, did you want to author that motion?
I can. I don't mind.
Okay. All right.
I move that the zoning administrator did not err, and in light of the overwhelming evidence that this is a case where, I make the motion that the applicant not be allowed to apply for a permit 1 year from today's date.
And I would second that.
That motion is by Ms. Davis. It's seconded by Mr. Lawless. Is there any discussion on the motion? If seeing none, then we'll vote on the motion and start with Mr. Newton.
In favor.
Mr. Pepper?
In favor.
Mr. Lawless?
In favor.
Ms. Davis?
In favor.
Ms. Carpenter?
In favor.
I'll vote in favor also. That motion passes unanimously. And unless there are any other announcements, I believe we are done with the meeting today.
Motion to adjourn.
All right.
Stay safe, everyone.
See
y'all. See everybody later. Talk to everybody later. Bye-bye.
Be good.